So this is the agenda that we have today. I'm going to talk a little bit about law services. Just give you some general information. Obviously, if you have any questions about that, you could either put it in the chat or you could call me directly. That's what I do here. I get the calls from advocates, so feel free to do that. I don't want to take up too much time on law services because I want to get into the meaty stuff that Nancy's going to discuss about student loans. So we handle over 6,000 cases each year. We are happy to report that we've grown over the years. A lot of that was due to because of the pandemic and also for the need on Long Island. We do direct representation, phone consultation, referrals, brief service. We have offices located in Hempstead, Islandia. Hempstead is the Nassau office. Islandia is the largest Suffolk office. And we also do the Riverhead office, which is for the East End, east of 112. We have attorneys, paralegals, and social workers. And we also have partnerships with community agencies. These are the addresses for all three offices. If you're ever wondering, clients, we do prefer clients have an appointment, but if you ever are wondering if it's something that we handle, you can call me directly, as I am in the Legal Support Center for Advocates, and my phone number is 631-232-2400. My extension for advocates only, please, it's an advocate service, is 3324. Feel free to contact me if you ever have any questions about where this client should go, or if we handle the type of legal issue that the client's experiencing. Here are a few of our programs. Most of our programs, like I said, we've added a lot more programs over the past few years. We're very happy. We're one of the largest provider of free civil legal services on Long Island. We have in the family law, we have the domestic violence court project. This second unit is actually the child support defense unit. So that's helping respondents who may not be able to pay their arrears. And they're usually clients that are on benefits, disability benefits. We have disability and health related projects, the HIV unit, the mental health law project, ICANN, that's managed long-term care advocates, education and disability rights, the disability advocacy project that deals with claims, so Social Security claims, SSI and SSD. Our housing units are one of our biggest units, the civil unit, which is eviction defense, and it's all about making sure that someone maintains their housing, and the foreclosure project. Our other different units, specialized units, consumer debt, veterans' rights, civil rights, public benefits, adult care facility. Senior citizen unit is only in Nassau County. We have our pro bono project. Those are lawyers that private attorneys that volunteer their time. That's in Suffolk. And in Nassau is the Volunteers Lawyers Project. And the Community Legal Help Project is another one of our newer projects. So, as I said earlier, I'm the Director of Community Relations, and I work in the Legal Support Center for Advocates. Any advocate that calls in will either get me and Hannah Fitzpatrick, Hannah is on, or Sharon Campo. And what we do is we try to provide technical support to you. Usually I get calls when someone has a client that they're meeting with right then and there, or, you know, clients that they've spoken to that they need to help, and we try to brainstorm on how the client can get assistance from our office, or how we usually have referrals. So we try to provide you with documentation and the law to help your client. If it's not something that we don't generally handle, we have a large resource bank on resources and how to assist clients in any way, especially pertaining to the issues we handle. And lots of times we get issues that we don't handle, but we have a referral for you. We do community trainings, just like we're doing this one, and we publish the newsletter. Vivian just put in the chat that all this is on our website. It is on our website. Okay. These are important dates to remember. We have another upcoming training on September 13th. Understand the importance of advanced care directives. So don't forget to sign up for that one. That's an interesting, very interesting one. They're all great, these trainings. So the more you learn, the more you empower yourself and you empower your clients. And then there'll be a little bit learn about the Volunteer Lawyers Project and the Nassau County Community Legal Help Project. That's another one. Those are units that have private attorneys that get involved and assist as well. Save the date for the Legal Resource Fair. We're doing it at the Brentwood Public Library. Tell your clients about it. It's going to be a lot of different legal issues regarding basic needs like housing. And then we have a Legal Services of Long Island open house. Notice I said Legal Services of Long Island open house. Effective September 16th, our name will be changed into Legal Services of Long Island. So and we want to celebrate that. It better describes the mission. And we do get a lot of funding from the Legal Services Corporation. And we will be changing from Nassau Suffolk Law Services to Legal Services of Long Island. It's going to be plastered all over the place, so you'll get to know it. We have our new logo, which is so pretty. And we have our new tagline, which I absolutely love, where dignity meets justice. So September 16th, you'll notice we'll have more new emails. Our website will look a little different with the new branding. And we are very excited about this new move. We'll be celebrating our 40th anniversary. I'm sorry, take that back. We'll be celebrating our, wait, is it the 40th? Nope. I just celebrated my 40th anniversary. Sorry about that. We'll be celebrating our 60th anniversary in 2 years. So it's time that the name represents what we do. So that's our name change coming soon. Okay. Now I'm going to pass the baton over to Nancy Neerman, and she's going to get some in-depth stuff about managing student loans to everyone out there. Thank you.
Thank you so much, Kathy, for the introduction and for your information on Nassau Suffolk Law Services, soon to be, gosh, I can't even remember.
Legal Services of
Legal Services
Long
of Long Island. I know, I'm going to have to get used to that. So my name is Nancy Neerman. I'm the Assistant Director of EDCAP, our Education Debt Consumer Assistance Program. We are a New York State funded program that offers free counseling and advice to borrowers that are struggling with student debt throughout the state. We are a program initiative of an organization called Community Service Society, which is a large nonprofit that's been operating actively in New York for close to 180 years. At EDCAP in 2022, we established a network of organizations. So we have 11 community-based organizations around New York State that also provide these direct services based on information and training that they receive from us and that they get on their own. And one of those organizations is Nassau Suffolk Law Services. So we're very happy to be here on behalf of EDCAP and Nassau Suffolk Law Services to do this presentation for you. So a little bit of housekeeping. I'm going to be doing the presentation, but my colleague, Vivian Storm, who's a lawyer at Nassau Suffolk Law Services and works on the EDCAP project, is going to be behind the scenes answering your questions. So if you have any questions that come up during the presentation about what I'm talking about or about anything pertaining to student debt, you can type them in the chat. Vivian will answer them or attempt to answer them. And then I'll be breaking periodically so that we can share some of these questions with everybody. So with that, I am going to turn my camera off and we will get started with the presentation. So one of the, one of the things that we generally do when clients come to see us, they usually come to see us because they have an immediate need. So they are struggling with their repayment plan, or they may be in default and need to get out of default, or they may be on the verge of going into default and don't want to get into default. And so, of course, we're always there to address the immediate need, because it's important to make sure that people can manage the short-term issues. But one of the things that we like to do as an organization is also leave every client with a strategy, because ultimately, at the end of the day, your goal is to get rid of this debt one way or another. And what we have found is that the vast majority of our clients are going to fall into one of three buckets when it comes to strategies for repaying student debt. Um, in the first bucket, we would have the pay the debt in full as quickly as possible, folks. That's a strategy that's generally suitable for people who have relatively high incomes compared to their loan balances. They have the ability to make lump sum payments or make payments that are more than the required monthly payment. Um, if you're in that situation where you just feel like you want to get it, your strategy is to pay the debt off, which most people, when they take on debt, that's what they think they have to do. Then the more aggressive that you pay on a monthly basis, the quicker you'll pay and the more you'll save on interest throughout the life of the loan. The second bucket, which is probably where the majority of our clients fall, is the folks that are pursuing what's a very viable strategy and a unique strategy when it comes to student loans, in the sense that they're pursuing a forgiveness program. And when you're pursuing a forgiveness program, the reasons for generally doing this are because A, you qualify for the forgiveness, or because there's really no way that you're going to be able to pay this debt off on your own without some help from some kind of forgiveness program. And when you're pursuing a forgiveness program, the idea is to make the minimum required payment until such time as you receive that forgiveness. So it's a very viable strategy within the student loan world, that the goal is not necessarily to pay off the entire debt. And that kind of differs from a lot of other types of consumer debt, because most other types of consumer debt needs to be paid off, or you're just going to default and go into collections. With student loans, you do have this option. This is going to really be the best option for people who have relatively high loan balances, but low to moderate incomes. Or they maybe are pursuing a forgiveness program like public service loan forgiveness, where you're working in public service and you pay your loans for 10 years, after which the balances are forgiven. So if you're pursuing that kind of strategy, it's important to know, because people are always asking me, who are pursuing this particular type of strategy, should I make extra payments on my loans? The analysis is, you need to look at the size of your debt and determine if it's realistic that you can pay that debt back faster than you can get forgiveness. So let's just take the example of somebody who's pursuing public service loan forgiveness, where you can get that by paying after 10 years. If your balance is $100,000 and you're making $50,000 a year, it's unlikely that you're going to be able to pay that entire debt off in less time than you can get your forgiveness. In that case, you want to just enroll in the cheapest repayment plan that you can find, which is generally going to be one of the income-driven repayment plans. Make those payments until you get forgiveness. It doesn't make sense to put extra money towards the debt if that's the strategy that you're pursuing. And then the final category, which sounds a little bit morose, but there's a reason that we put it in there, is pay the minimum required until death do you part. So this is generally going to be for older borrowers, people that may have taken out loans for themselves late in life, or Parent Plus loans for their children, who maybe are at or are approaching retirement, and they're just not going to have the employment requirements to allow them to earn forgiveness in a shorter period of time. You may find yourself just basically saying, well, I may have to spend 20 to 25 years paying this off, which could be the rest of your life, in which case you just find the cheapest repayment option and you make those payments until you pass. And the reason that we put this in here is because, unlike most other types of consumer debt in the United States, if you have federal student loans and you're the primary borrower on those loans and you pass away, the debt does not pass down to your does not become the responsibility of your beneficiaries. So just know that you make these payments, and once you pass, it doesn't become a burden on your loved ones. So we're going to stop and talk a little bit about the legal challenges, because, as you probably all are aware, There have been some lawsuits that have been filed against the student loan system. And I'll preface everything I say from here on in with just the fact that it's a very challenging time to be counseling people on student loans right now. There's a lot of uncertainty in the system because of these lawsuits, particularly when it comes to repayment options, which we'll go through, and we'll try to answer your questions as best as we can, but just understand that the legal process needs to play itself out until we ultimately know what the options are going to be for people in terms of the kinds of repayment plans that they enroll in, and how you might achieve some of your forgiveness goals. So a very short synopsis of the challenges. So the core challenge is to the most recent repayment plan, which is called SAVE. That's generally the cheapest option for most borrowers. It was introduced last year, just before payments resumed in October. And in addition to the plan itself, there were a bunch of regulation changes, or changes that they plan to make to the system that involved more than just the SAVE plan, that were involved in these SAVE regulations. The court challenges are against SAVE and all of the related regulations. And so there were, back in April, I think was when the first lawsuits were filed. There were 2 lawsuits led by Kansas and Missouri, and each one had a number of states' attorneys general who are participating, who are challenging the SAVE plan again and all the related regulations. As a result of a bunch of back and forth in the lower courts, a federal appeals court in Missouri has now blocked the Department of Education from enrolling any borrowers in the SAVE plan or offering forgiveness through this plan until all the legal issues are resolved. We don't know how long this is going to take. Certainly months. It could be longer. The Department of Education has filed an emergency petition with the Supreme Court to actually address the order that blocked the most recent order from the Eighth Circuit that has actually blocked the access to the SAVE program. But we just don't know when they may respond and what the result of that response might be. So as a result of all of this, what's happened is that borrowers who were enrolled in SAVE at the time of this, that this ruling came out, which was mid-July, are being placed in a non-interest-bearing forbearance. But time spent in this non-interest-bearing forbearance is not going to qualify for forgiveness. Now, there may be ways to get credit for things like PSLF for these months by using something called the PSLF buyback down the road. But for now, just know that if you were in the SAVE plan when this ruling came down, you should be in this non-interest-bearing forbearance. But those months that you're in that forbearance will not earn credit towards forgiveness. Another result of this action, of the court actions, is that the online IDR and loan consolidation applications are not available. They had to shut those down until they can determine exactly what they can and can't offer. So anybody that wants to submit an application for income-driven repayment plans or for loan consolidation has to do it on paper right now. You would submit that to your if you're just doing an IDR application, you would submit it to your existing servicer. If you're doing a consolidation application, you would submit it to the servicer who you want to consolidate your loans. But right now, the department isn't processing any income-driven repayment applications for SAVE or any other IDR plans at this point. They are processing the consolidation applications. However, you should expect long delays on all of this. And like I said, the court ruling affects other features of the IDR system. So that might include how you might get retroactive credit towards the IDR forgiveness program if you decide to consolidate your loans. And there's a whole host of other things that it may impact. So there's really a lot of uncertainty right now. We'll do our best to help you navigate through all of it. But you know, I'm sure that if we were going to do one of these in 2 or 3 months, there'd be a whole bunch of new updates. Potential outcomes of all of this stuff, for lack of a better word, is, of course, the best case scenario is that the court cases are all rejected and all features of SAVE and the related regulations are available, and that would include reduced payments for borrowers with any undergraduate school loans in the SAVE plan, shortened path to forgiveness in SAVE, more periods of forbearance and deferment being counted towards IDR forgiveness, not just in the SAVE plan, but in all of the other income-driven repayment plans. And then borrowers who consolidate their direct or FFEL loans will not lose retroactive credit towards IDR forgiveness. So that's all, and other things are included in the regulations. That would be the potential best outcome. You can handicap it the way you see it. I'm not sure that that's a realistic expectation, but we'll see. Worst case scenario, of course, is that the courts rule that the SAVE plan and all the regulations are associated with it is illegal. The IDR program then reverts to the pre-SAVE rules, which would mean that instead of SAVE, you would have the option of investing in something or enrolling in something called the revised pay-as-you-earn plan, and then some of the other income-driven repayment plans as well. Most likely, if this were to happen, is that borrowers who were enrolled in SAVE would be transitioned back to revised pay-as-you-earn. But again, stay tuned because we really don't know how it would play out. But what would more than likely happen is that payments would increase across the board for borrowers who were in the SAVE plan. And then borrowers consolidating direct or FFELP loans for IDR forgiveness, not for PSLF, but for IDR forgiveness, would reset their forgiveness count to 0 if they did that. And then the middle ground, which may be the best case scenario, or the best that we can hope for at this point, is that the courts allow some features of the SAVE plan to move forward, but eliminate other features. So this scenario could maybe play out as follows. So maybe the SAVE plan remains the cheapest option for most borrowers, but the reduced payments for those with any undergraduate school debt would not be allowed. Probably no shortened path to IDR forgiveness, which was one of the things that the SAVE plan offered. That would probably go if they did a partial adjustment. But what would be a very good outcome of this middle ground is that the other rules that are part of the SAVE regulations are left intact. So that would actually be a relatively decent outcome, the middle ground, short of the worst case scenario. So navigating the current environment, like I said, litigation has just introduced a whole lot of uncertainty into the system. So you want to err on the side of caution at this point and seek advice before doing anything complicated. Like if you're considering consolidation, there's a whole bunch of factors that one has to take into account before you actually do a consolidation. Right now, it's a little bit complicated, but you should definitely reach out to Nassau Suffolk, to the EdCap team at Nassau Suffolk, and they can certainly help you navigate through some of these like tricky things right now. When you get the deck, and I know this deck is going to be sent out to everybody who registered, I have some links here to the Federal Student Aid page and the Department of Education landing page that just provide some updates on the court action. So you can bookmark those links and periodically check them to see if there's any important updates, which, there was just one yesterday. So you never know when one is going to come out. Okay. I'm going to go on and talk about repayment options. So in light of everything that I just said, when it comes to income-driven repayment plans, you have to take what I'm about to say with a little bit of a grain of salt, because we don't ultimately know how this is all going to pan out. But when in the federal student loan system, there are basically 2 different ways to pay your loans. So you can either pay your loans via the traditional repayment plans, which is where the payments would be based on your loan balance, the interest rate of the loan, and some predetermined payback period. This is like paying back any kind of regular consumer loan. So it's like paying back the fixed versions of these loans are like paying back a mortgage or an auto loan, where you make one monthly payment over the life of the loan, after which you paid off the entire debt, including all of the interest. The alternative to that, if you can't afford it, is something called an income-driven repayment plan, or an IDR plan. And when I say income-driven or IDR, that's an umbrella term for 4 different plans that we're going to talk about in a little bit. But in terms of the pros and the cons of these different repayment plans, so with the traditional plans, the payments are predictable. right? So you just, the payments are fixed in the fixed version of the plan. You get one payment over the life of the loan. There are graduated versions of these plans where the payments start out a little bit lower, but they go up every 2 years. Doesn't have anything to do with your income, but you know what the payment schedule is. In certain circumstances, you can get your loan paid off faster in a traditional plan than you might be able to through one of the IDR plans. It's easier to administer the traditional plans because you don't have to recertify your income. So once you're in the plan, you're just in the plan. You don't have to file annual recertifications or income verification. And again, these types of plans are going to be best suited for people who could basically afford to pay them, particularly if it's a 10-year fixed plan, who have relatively high income compared to their loan balance. The downside of the traditional plans is that for a lot of people that maybe go into repayment for the first time after coming out of school, they just can't afford the payments in the traditional plan. So when you when a loan goes into repayment for the first time, the default repayment plan is the standard 10-year fixed repayment plan. Now, and if you're coming out of school for the first time, or just, maybe finished a program, a graduate program, and that loan goes into the repayment for the first time, and particularly if you have a sizable amount of debt, you may not have the job that you hope to have one day, or you may not have any job at all, in which case you're just not going to be able to afford these payments. The other downside to traditional plans is that the flexibility in adjusting plans is very limited. You can either do the fixed version of the plans or the graduated version of the plan, but that's it. And then if you remain in these plans, for most of them, any payments in the plan will not count towards forgiveness. In the standard 10-year fixed plan, some payments do count towards forgiveness, but if you remain in the plan throughout the life of the loan, you would pay the entire debt off. And just so you're familiar with the terminology, the names of these plans could be anything could be called standard plans, extended, graduated plans. The payback periods of these plans range from 10 to 30 years, depending on whether your loans are consolidated or not consolidated, and depending on the size of your debt. So the alternative to the traditional plans, if you cannot afford them, which many people can't, is the income-driven repayment plans. The benefits, of course, of the income-driven repayment plans is that the payments are going to be based, for the most part, on your income, your tax filing status, and your family size. So in 3 out of the 4 plans, the payment has nothing to do with the size of your debt or the interest rate, which could make them a lot more affordable. Loan forgiveness in all of the IDR plans offer forgiveness if you're making payments from anywhere from 10 to 25 years. We'll talk about the 10-year forgiveness in a little while. That's the shortened path to forgiveness in the SAVE plan. In all of the other plans, it's going to be a 20 to 25-year path to forgiveness. Income-driven repayment plans are generally required if you're pursuing IDR forgiveness, or if you're pursuing public service loan forgiveness. The other big pro, of course, is that you can adjust the payments anytime your income changes. So typically, when you enroll in an IDR plan, the payment is good for 12 months. But if your income declines before those 12 months are up, you can actually recalculate the plan and make a payment based on that lower income, so that you're never having to make a payment based on an income that you no longer have. And again, this is going to be best suited for the people with higher debt balances, low to moderate incomes, or who are pursuing certain forgiveness programs. The downside to the IDR plans, the administration, you do have to file this annual recertification and verify your income on an annual basis. The department is attempting to make that easier by offering sort of an automatic recertification process. But that's actually part of the new SAVE regulations. So I don't think it was the intention of anybody to eliminate that option, but it's tied up in the legal wrangling. So we'll see what happens with that. And then IDR plans, you could wind up paying longer because you're paying a lower amount, or you're pursuing maybe IDR forgiveness that takes 20 or 25 years. But, if you can't afford the payments in the traditional plans, at least you have a means of keeping your loans in good standing by making these lower payments. And then the names of the plans, as they stand now, again, the IDR plan options are subject to change. Savings for a Valuable Education, or the SAVE plan, that's the one that's being targeted by the courts. Its predecessor were called revised pay-as-you-earn or repayee. There's the pay-as-you-earn plan or payee. Right now, that plan is not going to be offered to anybody who was not already enrolled as of July 1st. Then there's income-based repayment or IBR, which is often confused with IDR, but income-based repayment is actually one of the repayment plans. And then the last one, income contingent repayment plan or ICR. That plan also is not going to be right now not offered to non-Parent Plus borrowers who are not already enrolled as of July 1st. But we'll see what happens after the lawsuits are resolved. The SAVE plan, and just again, if it survives, this is one of the reasons I'll go through why this was such an attractive plan. So first of all, there is an interest subsidy in the SAVE plan. I should step back for a minute. SAVE is going to be the cheapest plan for the vast majority of borrowers, not for everybody, but for most borrowers. The interest subsidy, unlike the other three plans, if your payment does not cover the interest charge in the SAVE plans, then the unpaid interest will not accrue to your account. So in all the other plans, if you make a payment and it doesn't cover interest, which is often the case if you have a large loan balance and a low income, then the unpaid portion of the interest would be added to your account every month, which is why people's loan balances would just balloon over time. In SAVE, that doesn't happen. What happens is every month, if that payment doesn't cover that charge, the government basically writes it off. The forgiveness component, again, with IDR forgiveness, that's forgiveness that you get just from being enrolled in any of the income-driven repayment plans. In all the other plans, it's either 20 to 25 years. In SAVE, for borrowers that had relatively low balances, so $12,000 or less when they originally went into repayment, you could potentially get forgiveness after 10 years for any extra $1,000 worth of originally dispersed balances. You would have to pay an extra year up until the 20 or 25-year maximum. Treatment of spousal income. So in the predecessor to SAVE, which was revised pay-as-you-earn, your spouse's income would be included in the calculation for the IDR plan, regardless of how you filed taxes. So even if you filed your taxes separately, they would include your spouse's income for the purposes of calculating the IDR payment. Under the SAVE plan, that changed to make it more in line with all the other plans, which say that if you file your taxes separately, your payment would be based on your income alone and not include your spouse's. Eligibility for SAVE. So anybody with a direct loan was eligible for the SAVE plan, except people with direct Parent Plus loans. For people that had non-direct loans like FFELP loans, Perkins loans, or HEAL loans, those can be consolidated to access the SAVE plan. But again, just kind of going back to my comment a little bit earlier, you want to be a little bit careful about consolidation right now. So you want to reach out and get some advice for somebody before you're consolidating your loans in this kind of environment. And just a quick word about direct Parent Plus loans, because those also have their own set of complications. Direct Parent Plus loans are not eligible for any of the income-driven repayment plans, but they can be consolidated to gain access to the ICR plan. And on the EdCap website, we do have like a whole section that just talks about management of Parent Plus loans, or you can reach out to a counselor for help. I also do want to quickly mention the on-ramp. So the on-ramp was basically a grace period that the Department of Education announced at the time that we went back into repayment last October. And is meant as a means for people to basically smooth the transition from 3.5 years of payment pause back into repayment, knowing that there were going to be some hiccups and glitches. And what it allows borrowers to do is basically skip payments in any of the repayment plans, whether it's the traditional plans or the IDR plans. If you skip your payments during this time period, then basically no late fees are going to be incurred. The missed payments are not going to be reported to the credit agencies, and you don't risk going into default. Now, I do want to mention this was only available to people who were eligible for the payment pause. or who currently have direct loans or Department of Education held loans. If you still have Perkins loans, if you have like a commercially held FFELP loan and your servicer is AES or Navient, these rules do not apply to you. But for the vast majority of borrowers, this is the on-ramp is an option. However, this option does end at, or is slated to end at the end of September. We're pushing the Department of Education to extend that option, but we don't know if that's going to be the case. So if you haven't chosen a repayment plan right now, again, if you've been skipping payments, that's fine. It's not going to harm you up through September 30th, but by October 1st, you need to either be choosing some kind of repayment plan or in some kind of forbearance while you're waiting to enroll in a repayment plan, unless you can afford the payments that they're asking you to make right now. One other thing about the on-ramp is that these skip payments don't count towards forgiveness, and people do get delinquency notices, even though the delinquency notices really kind of don't have teeth right now. So before I go on to the next section, Vivian, I'm going to stop there and see if there are any questions that we want to address.
Yes. One question was about the double consolidation loophole for Parent Plus loans.
Just what's the status of that?
Right, right.
So double consolidation was supposed to be a workaround for Parent Plus borrowers who, after consolidation, only would have access to the ICR plan, which tends to be a very expensive plan. And the idea behind this is if you do a series of consolidations, then by the time you get down to the last consolidation, it wipes away the code that indicates that there were Parent Plus loans in the consolidation loan and allows borrowers to access cheaper repayment plans. The Department of Education actually addressed this loophole because it is a loophole. Like, you're not technically allowed to do that. But they addressed the fact that this loophole existed and basically grandfathered it in as long as your consolidations were completed by July 1st of 2025. Now, that writing is in the SAVE regulations that are being challenged. It's just a big giant question mark whether or not people are going to be able to do the loophole. That's not to say that you shouldn't try. There may be instances where, frankly, that, if you can't afford any repayment plan, that may be your only hope at getting access to a cheaper plan. We just cannot guarantee at this point that it's going to work. And even for those where it's worked and people were enrolled in SAVE now, because most people that did that were trying to get into the SAVE plan, we don't know if they're going to be able to stay in the SAVE plan, and we don't know whether they're going to have access to repayment plans other than the ICR plan. Again, always with Parent Plus, it becomes very complicated. You want to reach out for individual assistance. What I will say is you have to remember with Parent Plus, when you're consolidating, any direct consolidation loan that contains any Parent Plus loan is going to be subject under the rules only to the ICR plan. So if you have a lot of debt for yourself and some Parent Plus debt, at this point, for the most part, we would not encourage you to consolidate them all together, because then you could potentially subject your entire balance to the ICR plan, which might be very expensive for you. But there may be other instances where we'd be just like, well, look, you got nothing to lose, so why not give it a shot? You're no worse off after consolidation than you are prior to consolidation, so you might as well try, but you need to see a counselor so that they can look at your loans and determine whether that's the best option for you.
Should borrowers who are seeking PSLF credit try to make payments right now, given the status of the SAVE litigation?
Okay, so that depends. So if you're currently enrolled in an IDR plan other than SAVE, so if you were enrolled in IBR or PAYE or ICR and you're pursuing PSLF, make your payments and you will continue to get credit towards PSLF. If you're in the SAVE forbearance, making payments while you're in the save forbearance is not going to make those months eligible for forgiveness. So there's another process that you may have to try down the road when you're closer to 120 qualifying payments, called the PSLF buyback, that allows you to buy back credit for months that were not eligible for forgiveness. So if you made a payment now and you're in the save forbearance, it's just going to get applied to a month after the save forbearance is over. It's not going to help you get credit towards forgiveness right now. My general suggestion for people that are, because this is a big dilemma right now for people who are pursuing PSLF, particularly those who are close to getting PSLF, is how to get your credit towards PSLF. My general suggestion is don't make the payments while you're in forbearance if you want to get PSLF credit, but put that money aside into a bank account, the payment that you would have made into a bank account, so that if down the road you need to do the PSLF buyback, you may have, if you're buying back multiple months, you may have to do a lump sum payment, and that money will be there kind of waiting to do something like that. The other option for people who are eligible, and this may not be everybody, is that some payments in the standard 10-year fixed repayment plan, that's one of the traditional plans, actually do count towards PSLF. If you're eligible for that plan, and if you can afford the payment, you can actually switch to that plan right now, and make your payments towards PSLF until all this legal stuff is over. But just remember, A, make sure that you can afford the payment, and B, if you have consolidation loans, it's highly likely you're not eligible for the 10-year standard fixed plan. So if you want to go into any other kind of like extended traditional plan, that's not going to count towards PSLF. And that's one of the things maybe you would want to consult somebody before making that switch. The other option, of course, for people that are pursuing PSLF is try to switch to another repayment plan, like another IDR plan, but they're going to be so backed up on processing these applications. It could take many, many months for the new application to be processed, and probably all but 2 of those months would not qualify for PSLF. So I know it's a sticky situation right now, but it might just require being a little bit patient for a month or 2 to see if there's any new developments, and make a more, if you're a ways away from PSLF, you may want to just kind of stay put for now. If you think if you think you're very close to 120 qualifying payments, reach out to one of the counselors, and we'll maybe try to, help you figure out what the best option is for you.
We also got a question related to concern about whether servicers provide correct information. I'm going to break it down into a series of more discrete questions. So how can I make sure I'm getting correct information from my servicer? How can I determine my progress towards forgiveness? And what do I do if I disagree with my servicer's determination about my credit towards forgiveness?
So the first question is really hard to answer, because I will say flat out, there's a lot of misinformation coming out of the servicers. There frankly has been for years, and I think there's just the level of confusion is so high right now, that there's probably not a lot of good information coming out of the servicers. Now that you have this resources, you can either check with NSLS. You can check the EdCap website. We have a lot of resources on the EdCap website, or you can always contact our programs to ask specific questions. Sorry, what was the second question, Vivian?
The second, how can I determine my progress towards forgiveness?
So for public service loan forgiveness, the PSLF trackers now, if you have one, are on the federal student aid website. That's the studentaid.gov website. So remember, for those of you who might remember, that you used to have your loans at MOHELA if you were pursuing forgiveness, and there would be a tracker on the MOHELA website. In July, they transferred that function over to the Department of Education. So it's all being done on the federal student aid website. But you do have to file a PSLF certification form in order to get qualifying payment credit. And if you've never filed those forms before, you're not going to have a tracker. So you need to start by filing those forms for every employer that you've had since October of 2007, or later if your loans were dispersed later. And that form just verifies that you've met the employment requirements of the program. Once those forms are filed and processed, you'll be provided with a tracker, and then you can track your progress towards PSLF. One piece of guidance right now is there's different ways to file that form. You can file it using the PSLF help tool on your federal student aid account, and then select an electronic signature or a manual signature. We strongly recommend that you select the electronic signature. That's for your employer to sign off electronically, because we know that those applications are being processed way more quickly than the ones with manual signatures right now. And again, you can reach out for some help to do that. And then the final question again.
The final question is, what should I do if I disagree with my service's determination about my credit towards forgiveness, whether it's PSLF or IDRF?
Okay, so first of all, with IDRF, and I was going to talk about this in a minute. With IDRF, there is no tracker yet. But as a result of the IDR account adjustment, which was this one-time account revision, sometime this fall or later in the year, the department is supposed to determine how much credit all these borrowers have through this IDR account adjustment process, notify you of how much credit you have towards IDR forgiveness, and then provide a tracker on the federal student aid website. Right now, that's not available. But hopefully later this year, you would know exactly where you stand, which would be fantastic. For public service loan forgiveness right now, if you don't agree with the count, you can either contact, there's a phone number on the federal student aid website, which I don't have off the top of my head. I think it's an 888 number that you can call to request, to inquire about what's going on with your PSLF count. You can also file a reconsideration request. That generally has to be done within 90 days of you receiving the update of your count. That also is done through the federal student aid website. Or if nothing works, you can submit a complaint to the to federal student aid, or you can submit a complaint to the Department of Financial Services here in New York State. And I'm pretty sure I have in the back of I'll double check, but I think I have in the back of this presentation links to the DFS complaint portal and to the FSA portal, where you can also escalate to the ombudsman.
One last question. What should people do if their IDR anniversary date is coming up, so that they can make sure that they're renewing in time?
So this is a very good question, and I'm not sure I'm going to be able to 100% answer this. Well, if your renewal date is coming up and you're not if you're not in the save forbearance, let's say you're in IBR or you're in ICR or payee, you should get notification a good 2 to 3 months in advance from your servicer that your recertification date is coming up. Now, for most borrowers, the Department of Education had a while ago said that no IDR plan would expire before November 1st of this year. So if you had a plan that was expiring on November 1st, very soon you should be getting recertification notifications. But you can always contact your servicer if you haven't received one of those notifications and you think it's coming up. Generally speaking, if you log into your servicer account, so that's Mohila or Advantage or Ed Financial, and you click on an individual loan, you should see like the IDR plan you're in and the date that it expires. But you can reach out to the servicer if you haven't received notification and you think you need to do something. For people who are in the save forbearance, whose recertifications are coming up, and I do have a client that has a recertification coming up or an expiration date coming up in December. I don't really know what they're expecting people to do in that situation. Again, you can reach out to the servicer, but I think that's one of the questions that I think we need to get answered. over the next month or so from the Department of Education. What should people do in that circumstance? Start by reaching out to your servicer if that recertification date is coming up. You can, if you want to recertify, you can submit that application, but that, like any of the other IDR applications, it's not being processed right now. And you should not be held accountable for the fact that it's not being processed, just so you know.
Okay, I think any other questions will hopefully be addressed in the next section. If I missed your question, or if Nancy's comments prompted additional follow-up questions, please feel free to put them in the chat, and I'll run through them with her after her next section break.
Okay, and I'm sorry. I know we're gonna wind up going over here because I know we're 4 minutes away from 1:30. But there's just a lot of questions and there's a lot of stuff to cover. So bear with us and thank you for your patience. I'll try to get through this next section as quickly as possible, and that's about forgiveness. So I just generally kind of like to go through forgiveness programs that everybody should kind of know about. And we'll start with the income-driven repayment forgiveness program. So that's the program that we've been talking about, which is if you make payments in any of one of those income-driven repayment plans for anywhere from 10 to 25 years, the balances would be forgiven at the end. There's no employment requirement associated with this forgiveness program, just that you need to be enrolled in the IDR plan and making your required payments. This is basically going to be the default forgiveness program for anybody with a large loan balance that can't afford the traditional plans, but maybe don't have the employment requirements that would allow them to get public service loan forgiveness or teacher loan forgiveness. Other thing to mention about this plan is that forgiveness in this plan after 2025 is probably going to be taxable at the federal level, and I'm not sure about, I don't think at the state, but definitely at the federal level. Public service loan forgiveness, I think people are probably relatively familiar with this, but this is a program that forgives your remaining loan balances after making 10 years or 120 qualifying months of payments. You must be in a direct loan to have access to public service loan forgiveness. You must be working an average of 30 hours per week for a qualifying employer, and the qualifying employer would be generally a not-for-profit organization or a governmental organization. The one thing that I kind of liked, a couple of things that you should know about PSLF. Number one, the payment credit in PSLF doesn't need to be consecutive. It can be cumulative. Forgiven balances are not taxable in PSLF at the federal level ever. The one thing that everybody should understand about PSLF is it's not about the job that you do. It's about your employer and whether or not they qualify and whether or not you work for enough hours. So you don't have to be a teacher. You don't have to be you don't have to be a nurse. You don't have to be a social worker. As long as you're working for a qualifying company and you're working the required number of hours, if you have student federal debt and you meet the loan requirements, then you're going to be eligible for PSLF. Borrower defense to repayment, or BDR, is for people who feel that their schools are guilty of some kind of misconduct or that they were defrauded. It's not for people who feel that like they didn't like their curriculum or they didn't like their teacher, or God forbid they were the victim of some kind of assault. It's for people who feel that the school did something criminal, like misrepresented the graduation rates or the job placement rates. It's a long, arduous application. You probably want to reach out for help, and it takes a very, very long time to get an answer. But if you feel that your school fits that category, you might consider filling that out. And then total and permanent disability discharge is kind of what it sounds like. It's for people that have some kind of a mental or physical disability that doesn't allow them to earn a livable wage. So it doesn't mean that you have to be bedridden or in a wheelchair. And you can work. It just means that you really can't work and perform activities that would allow you to earn a decent living. Changes to PSLF servicing, I think I mentioned this a few minutes ago. So starting in July of 2024, the qualifying payment count is now managed on your federal student aid account. So it's no longer at MOHELA. Now, if MOHELA was your servicer before, they're probably still your servicer now. Mohila is still going to be performing servicing functions like sending you bills, collecting payments. They would probably process your IDR applications and generally answer your questions. But questions about the PSLF count and the way you file the forms, that's all done through the Department of Education and at studentaid.gov. And I have some links here to the area that will show you the instructions. Again, I highly recommend that if you're going to file these forms, if you can, you want to request an electronic signature from your employer, which with your current employer shouldn't be an issue. Sometimes can be more problematic with previous employers, but do that if you want these applications processed in a somewhat timely basis. For everything else, expect kind of significant delays. And then the IDR account adjustment, I alluded to this a little while ago. The IDR account adjustment was a one-time account revision that allowed borrowers to earn retroactive credit towards IDR forgiveness, which can then be turned into credit for PSLF if you have the employment requirements, by offering to give credit to borrowers that had direct loans or Department of Education held FFELP loans, that they would award credit towards forgiveness going all the way back to when you first had those loans dispersed, at least as long as it wasn't any earlier than July of 1994, and give you credit for periods that you might not otherwise have been given credit for. So you might get credit for periods that you were in repayment that you never made a payment, or certain time spent in certain forbearances you would get credit for. You might get credit for periods of deferment, although not time in in-school deferment. And you would get credit for months prior to loan consolidation, because prior to this, once you consolidated your debt, if you had any accumulated credit towards IDR forgiveness or PSLF, you would lose all of that upon consolidating, and you would have to start from scratch. So people that had to take action to get to be eligible for this basically would have had to consolidate certain types of loans by June 30th. But if you have direct loans, if you have all direct loans, don't worry about it, because those will automatically be qualified for the IDR account adjustment. If you have certain types of FFELP loans, so if they were Department of Education held FFELP loans, meaning that those were loans that were eligible for the payment pause, then you also are eligible for the IDR account adjustment. But if you miss the consolidation deadline, you should probably reach out if you missed it, and we can sort of talk to you about whether or not you should still consolidate your loans, because in some instances you may still want to do that. But for the vast majority of borrowers, the department is now working on getting everybody that account. And then they will notify borrowers later this year how much credit you have towards IDR forgiveness, after which you would then know exactly where you stand. So these are the forgiveness programs that require 20 to 25 years of repayment. So I think it's going to be like a game changer, because you've never really known where you stand on this particular forgiveness program before. And the reason that they did this, by the way, is because this administration recognized that the IDR forgiveness program and public service loan forgiveness program, which had both been around for quite a while, were very poorly administered and were not functioning properly. And almost nobody got forgiveness through these programs up until the point where they implemented the IDR account adjustment. So this was a way to apply a general fix and do it kind of, without punishing borrowers, to give them the maximum amount of credit that they should get, and make up for the fact that basically, there was nobody keeping track of credit towards IDR forgiveness prior to this. So it would have been virtually impossible for anybody to get credit towards IDR forgiveness before this. Fresh Start is also for anybody that's in default. That's another temporary program that's coming to an end at the end of September. So this is anybody with a defaulted federal loan, or the vast majority of borrowers with a defaulted federal loan. Fresh Start is a potential option for you to bring your loans back into good standing, and also potentially clear up any credit damage to your credit reports if it's still showing up on your credit reports. But it is not something that happens automatically. You have to opt into this. So you need to take action. There's one of two things you can do. If you're continuing your education, you apply for FAFSA. What happens then is the loans get transferred to a non-default servicer. If you enroll in school at least half time, you get placed in an in-school deferment, and then your credit is repaired. If you're not going back to school, you just contact the debt collector, which in most cases is going to be Default Resolution Group. Or you can apply if you have an My ED Debt account, you could do that. Again, the loans will be transferred to a non-default servicer, and once you enroll in a repayment plan, could be any of the repayment plans that we talked about, the default history is going to be removed from your credit report. So this option is going to be available for about another month. It's a relatively quick phone call to DRG to get this going. It takes about 45 to 60 days to complete. It's probably the cheapest and fastest way to get yourself out of default at this point. And remember that collections activities have been suspended on defaulted federal student loans throughout most of the payment pause and continue to be suspended throughout the end of the Fresh Start initiative. But at some point after Fresh Start is over, maybe not immediately, people whose loans are still in default are going to be subject to involuntary collections again. So you want to kind of take this time to take action if you need to do that right now. And then I'm not going to, private loans, again, I think most people are probably familiar that private loans are a different animal entirely. Everything that we've just spoken about really only applies to federal student debt. Private loans are offered by banks and credit unions, private institutions. They generally don't offer the range of repayment options or payment options that are based on your income. And they offer no forgiveness in most cases. They require a credit check. They require cosigners. The cosigners are 100% liable for the debt if the primary borrower can't pay. And then, of course, the interest rates are determined by prevailing market conditions and by the applicant's creditworthiness. One big difference between private loans and federal loans is that they are subject to a statute of limitations, where with federal debt, the government can come after you forever. General rule on private loans, if you don't already have one, is this should be your last resort, or you should really try to avoid it if at all costs if you can. But if you have private loans and you're stuck, you can reach out to NSLS and they can counsel you. It's just that the number of options available to you are not what they are in the federal system. And that's it. Before we wind up and just go to questions, I did want to make one point about public service loan forgiveness and the lawsuits. Public service loan forgiveness is not a subject of these lawsuits right now. So the lawsuits are challenging the SAVE plan and forgiveness through the SAVE plan. That's IDR forgiveness through the SAVE plan, and may have some impact on people's ability to get access to some of the other income-driven repayment plans. But it's not targeting the PSLF program itself. So for PSLF borrowers, you still have the option of maybe consolidating direct loans and getting retroactive credit towards PSLF, but you want to make sure that you have a payment count on the loans before you consolidate. You eventually can get PSLF credit. It's just a question of, because of all the confusion with the income-driven repayment plans and the forbearances that don't count towards forgiveness, how you will be going about getting that credit over the next few months. That's a little bit iffy, but the program itself is not a target of these lawsuits. So I'm going to leave it at that, and Vivian, and maybe we can finish off with some final questions.
Sure. Are you aware of a program like EdCap for people who live in New Jersey or other states?
I am not aware of anything in New Jersey. I would say if you can reach out to EdCap if you, we can't actively promote our services outside of New York. If you know somebody in New Jersey that needs some help, they can call EdCap and we'll do our best to see if we can help them. EdCap's phone number is not on here, but it's 888-614-5004. There are other states that I know in California, they launched a service not exactly like EdCap, but the goal is similar, to provide borrowers with free counseling services for student loans. And I think that there are some other states across the country that are looking to do the same, but most states don't have an EdCap-like program, unfortunately. But if you live in New Jersey, contact your local legislators and your state legislators and tell them that you're interested in such a program.
So I think that covered all the questions I picked up in the chat. I don't know if you want to open it up to people to unmute and ask additional questions. Or if you had something you were hoping to ask, you can put it into the chat now.